As you know, the legislature passed about $827 million, by my count, in taxes and fees. About $390 million of that, let's round it off and call it $400 million, was passed without a two-thirds vote. If you look at House Bill 629, House Bill 624, House Bill 805, HCR 8, House Bill 93, House Bill 829, I think if you run the numbers, it comes out to about $389.7 million that did not receive a majority vote of either the House or the Senate or both. Article 7, Section 2 of our Constitution, the Louisiana Constitution of 1974, I think is pretty straightforward. I don't like to read things, but I think in this juncture, I think it might be helpful. This is Article 7, Section 2. The levy of a new tax, an increase in existing tax, or a repeal of an existing tax exemption shall require the enactment of law by two-thirds of the elected members of each house of the legislature. That has been the law in Louisiana for almost a century. It's not only in the 1974 Constitution, it was also in the 1921 Constitution, and the notes to the 1974 Constitution make it clear that the 74 Constitution was intended to continue the law under the 1921 Constitution. Now, as you know, the legislature received advice on which it acted that our two-thirds vote was not necessary in some instances. The business community, more specifically the Louisiana Chemical Association, has filed suit challenging at least one of those acts of the legislature, HCR 8. There will probably be other lawsuits filed depending upon how well the initial suit goes. Normally what happens when you contest the constitutionality of a tax statute, the companies doing it, or the individuals, will do what they call pay under protest. That means they pay the money to the Department of Revenue, and the Department of Revenue escrows that money, so in case the Department of Revenue loses the litigation, the money will be there to pay back to the taxpayer. The division, or rather the Department of Revenue has decided in this instance not to do that. They waived the payment over protest. They're going to take the money and spend it. Ultimately, if the business community prevails, the new governor and the new legislature will have to find the money to refund. So it's an important issue. It's an important issue in the short term, it's an important issue in the long term, and I think it's an important part of state constitutional law. I don't know how the lawsuit will turn out. The legislature will be represented by probably by Butch Spear, who you know. Butch is the clerk of the House. He's an extraordinarily capable lawyer, very good lawyer. And the business community could lose. I'm not here to predict the outcome of legislation. I am here to tell you, in one person's opinion, what I think the state constitution says and what I think it means. If you know, state constitutions aren't enacted in a vacuum. If you go out to the LSU library, you will find 14 volumes of records from the Constitutional Convention of 1973. The convention met a little over a year. They met at the old White House Inn down here. It was torn down. I think the Division of Administration building is there now. For a solid year and a few weeks, the delegates who were elected by the people met. They met sometimes they went well into the evening. The only time they couldn't meet in the evening was Thursday night. They had to leave because there was wrestling on Thursday night. But other than that, they met for a year drafting the Constitution, and all of those documents are preserved. There are verbatim debates of the full convention on the floor of the Constitutional Convention. You can go look at what the committees discussed when they were putting together the proposals to be debated by the full Constitutional Convention. So not only do you find the verbatim debates on the floor of the convention, you find the proposals considered in the various committees, you find the committee notes from the various committees, you find the staff reports from the various committees. It's a treasure trove, if you care about state constitutional law, of information about what the delegates, the drafters of the Constitution, but equally important, what the voters, the ratifiers of the Constitution intended. And I think if you look at those records, as I have, some of you know I teach state constitutional law at LSU. That doesn't mean I'm an expert. I don't pretend to be. It does mean I've read the Constitution and a lot of the Constitutional Convention records. And if you go back and look at those records, not just look at the plain language of the Constitution, which I think is pretty clear, but if you go back and look at those records, I think what you'll see is that the delegates, and you have to assume the voters, understood the importance of a two-thirds vote and clearly intended there be a two-thirds vote requirement on using their language on all tax matters, end quote. That wasn't something the delegates just came up with. There was policy behind that. I mean, if you look, I'll quote you from one of the staff reports for the Committee on Revenue, Finance, and Taxation, which came up with the language from Article 2, Section 7. This is what the staff report says. This is from the research staff. Lee Hargrave, former chaired professor at LSU, was in charge of the staff. I'll quote from it. The greatest advantage of the two-thirds rule is in preventing the legislature from enacting tax laws which would place too much of a tax burden on the taxpayers. Accordingly, the two-thirds rule prevents the legislature from passing tax laws too hastily and without serious consideration. You will also find in those records a statement from the Public Affairs Research Council, which I'll share with you. This was the statement that Parr submitted for the record. I'll quote it briefly. The requirement of two-thirds of the elected membership of both houses to pass tax laws should be continued, as should the two-thirds requirement for the issuance of bonds, addressing persons out of office, and impeaching the governor, creating educational or charitable institutions, passing constitutional amendments, and a host of other unusually significant decisions the legislature is called upon to make. Again, these are Parr's words, not mine. Supermajorities of two-thirds, three-fourths, or other varieties are widely used throughout all levels of government in America. They are used not only in legislative decision-making, but they're used widely in jury decision-making. The supermajority is normally used to assure that in grave matters a substantial consensus is reached rather than half the people plus one. Supermajorities thus provide a semblance of stability. That's the policy behind the two-thirds vote. The idea that raising taxes, no matter what you call them, taking money out of people's pocket, is something that government needs to think through carefully. It shouldn't be done hastily. If you're going to do it, there ought to be deep and broad support. And again, I think if you look at the Constitutional Convention records, I mean, I just made a quick list. You can see it from some of the various documents. If you look at the comments to Article 7, Section 2 as it came out of committee, if you look at the staff reports, if you look at the verbatim transcripts, you will see that the delegates, when they were referring to Article 7, Section 2, intended it to include, their words not mine, quote, all tax matters. Now, I know there's some disagreement on that by some members of the legislature. They're relying on, I believe it's a 1993 Attorney General's opinion, which I've read. Many of you probably have too. To me, it's not on point because it deals with suspending a law. And while it's true that HCRS, the subject of the litigation, had to do with suspending the legislature only raised taxes in one instance by suspending the law. In the other cases, they just passed a statute. I suppose the argument of the lawyers for the legislature will be that, that the law is not clear, that it's uncertain. I disagree with that, obviously. They may argue, if you look at the language of Article 7, Section 2, it refers to new taxes, increases in existing taxes, and repeal of an existing tax exemption. Well, the legislature not only reduced some tax exemptions, but they addressed deductions, they addressed rebates, and they addressed credits. So I suppose the argument will be, well, the Constitution doesn't say anything about deductions and credits and exemptions, therefore the legislature can do it. And there's some credibility to that argument. I mean, I don't mean to sound too wonky here, but Louisiana's Constitution is different from the U.S. Constitution. The U.S. Constitution is based on delegated powers. If Congress does something and you challenge it, Congress, to defend itself, has to prove that there's a specific provision in the U.S. Constitution that says it has authority to do that. If Congress can't point to a provision of the U.S. Constitution that says it has the authority to do it, it can't do it. The Louisiana Constitution is completely different. The Louisiana Constitution is a constitution of plenary power. That means that the legislature can do anything it wants to do, anything, unless somebody challenging the act of the Constitution can point to a specific provision in the Constitution that says the legislature can't do it. You see the difference? Huge difference. That's why any act passed by the legislature is presumed to be constitutional. So the burden to overturn a statute passed by the legislature is heavy, as it should be. But the legislature has enormous power. Now, the legislature has ceded most of that power to the governor, as you know, but that's a topic for another day. So I'm well aware of the arguments, and they're good ones. But I still believe that the language supports the two-thirds vote requirement, and more than that, the policy does. If you look at a number of cases, a case, I'll be glad to give you the citations if you're interested, a case called Bessie v. Nix, decided by the Louisiana Supreme Court in 1977. Another case, a very famous case, decided in 1993 dealing with forced airship called Succession of Lauga. You will see that the Supreme Court, in interpreting a provision of the Louisiana Constitution, doesn't only look at the language. Obviously, the language is important. And I think the language in this instance supports the two-thirds vote requirement. But the legislature, or rather the court, also says you're supposed to look at the constitutional conventional records, which I talked about as well. But there's one more thing that the Supreme Court says we're supposed to do. You've heard this debate about being a strict constructionist. Strict constructionist doesn't mean you just read the language and whatever the language means to you is what the law is. A strict constructionist also is going to look at the policy behind the language. Let me read you a quote. Again, I'm sorry to sound so wonky, but this is important. This is a quote from How You Ought to Interpret the Constitution. Justice Dennis wrote this quote in a famous opinion called Succession of Lauga. Quote, in construing a constitutional provision, the courts may consider the object to be accomplished by its adoption, and the evils, if any, sought to be prevented or remedied in light of the history of the times and the conditions and circumstances under which the provision was framed. In other words, Why did the delegates put it there? Why did the delegates require a 2/3 vote? And I think the records and the policy are both clear. They required a 2/3 vote on, quote, all tax matters, end quote, their words, not mine, because they wanted the legislature to have a deep and broad consensus before raising taxes. Now, you may agree with that. You may disagree with that. But if you believe, as I do, in the rule of law, and I know you do, then I think if you don't like what the Constitution says, you need to change it. Let me give you one last example of what I'm talking about here. I hope I'm being clear. You can't just rely on the words of the Constitution. That's the point I'm trying to make. You've got to look at the policy. You've got to look at the debates. You've got to look at the committee records to see what's behind it. Let me give you an example. There's a famous case in Texas. It's called Director of Agriculture and Environment versus Printing Industries Association of Texas. It's a 1980 case. It dealt with the Texas Constitution. Texas used to have a provision in its Constitution that said all printing contracts have to go to the low bidder. All printing contracts in Texas had to go to the low bidder. Well, the Texas Department of Agriculture and Environment decided it could save money by doing the printing in-house. Well, you know what happened? The printers who had the business didn't like that much. So they filed suit, said, you can't do it. It's unconstitutional. Here it is in the Constitution, big as Dallas. All printing contracts have to go to the low bidder. Clearly, the drafters of the Constitution intended the private sector to do the work. You don't have a low bidder if you do it in-house. Pretty good argument based on the plain language. But then the Texas Supreme Court looked at the policy behind it. They looked at the records from the convention. And clearly the policy was not to choose between the private sector and the public sector. The policy behind the provision was to prevent corruption, prevent a politician from hiring his buddy who was in the printing business. So the Texas Supreme Court ruled, perhaps predictably, but at least in my opinion, accurately, that the decision to do the printing in-house was constitutional. Again, I don't know how this legislation will, or rather this litigation will come out. The legislature is very well represented. They may win. I predict if they do win, it'll be on a technicality because somehow the courts decide the language is unclear. I think it's very clear, but I will tell you this. If the legislature does win on this one, I think you will see a constitutional provision proposed at the next legislative session to make clear in the state constitution what I believe is already clear. It's been the law in Louisiana for 100 years. It's in the 1974 Constitution. It was in the 1921 Constitution. It's clear from the debates, the committee records, the comments to the committee records, the research reports. A 2/3 vote is required for all tax matters. And there's a reason for that. There's a reason for that. The voters have said categorically and unequivocally, in my opinion, that they want there to be deep and broad support in the legislature before taxes are raised. We've got some time for questions. I do want to hit a lick on one other subject. It's not one that Michael talked about, but it came up in the news recently. I saw where Commissioner Fannin says that the budget next year is likely to be about a $700 million deficit. We just finished our rating calls with rating agencies. They were successful in my opinion. I asked that they not downgrade Louisiana. I wasn't quite as ambitious as Commissioner Nichols, who wanted an upgrade. I would have been delighted to have an upgrade, but the rating agencies don't quite believe in the Louisiana miracle. We didn't get a downgrade, and I consider that successful. I'm very pleased. We argued, at least I did, that the new legislature and the new governor and the new treasurer and the new statewide officials should have an opportunity to get this car out of the ditch. All four wheels were in the ditch. We got one wheel out in the legislative session, but we still got 3 wheels in, and the new leadership deserves a chance to be able to get the car completely out. The subject that came up, one of the subjects that came up, had to do with mid-year budget cuts. And this is what I told them. I told them, look, our budget is balanced for now, okay? No one can rule out the possibility of mid-year budget cuts. There's some things we have to watch out for. Obviously, the price of oil. We have budgeted $62 oil. Oil's not trading at $62 today. I looked before I came over, it's about 42 and change. So obviously, we could have a revenue gap there. We could also have a gap caused by spending. The division administration and the governor have put in about $222 million in the budget of, quote, efficiencies. In other words, there's a line item that says, it's actually several line items. They say we're going to save $222 million this year throughout state government through efficiencies. And you ask them, well, what do you mean by efficiencies? And they say, well, just trust us. Well, we've been down this rabbit trail before, where 2 years ago, I think, actually 2012, they did the same thing to balance the budget, and the efficiencies did not come to pass. So obviously, we have to watch those $222 million worth of efficiencies and make sure that they do come to pass. We also have some one-time money in the budget, which we were very frank with the rating agencies about. We've got about $542 million in non-recurring revenue. That's the usual suspects. You've heard them before. Tax amnesty proceeds, fund sweeps. They used a bond premium to balance the budget. Hurricane disaster monies. They used debt defeasance, where you take one-time money and make your debt payment for 1 year. That's about $542 million. The biggest risk we're going to have that we've got to watch is our spending at the Department of Health and Hospitals. The DHH has said pretty clearly, I think, during the legislative session, and I believe they say the same thing now, that the amount appropriated to them is going to be short about $338 million from the money they're going to need. DHH says they need another $237 million for Bayou Health, another $60 million for community-based waivers, another $16 million for Medicaid prescription drug payments for our dual eligibles, and another $9.1 million for long-term personal care services. And there's one more I can't remember. So that's $338 million. So if you add that $338 million and the $222 million and the $62 oil, you can see that it's possible we'll have mid-year budget cuts. I'm not predicting them, and I'm certainly not hoping for them. But I told this to the rating agencies. They knew it anyway. They're analysts which file in Louisiana. They know as much about our budget as we do. But as I told them, look, it's not like we don't have experience with mid-year budget cuts. Okay, we've had 6 since 2010. If we have them, we'll deal with them. But hopefully we won't have them. Last thing I want to talk about, and I've got till 1 o'clock, don't I, Michael? I'm only. This will be my last comment. This is something I hadn't planned on talking about, but I think it's important. I don't need to tell you about the state's finances. We need to be real careful in the last few months when there's a change in administration. I've been through this before, and many of you have too. It's kind of the last few days of a legislative session. You got to be especially vigilant in those last few days. We have an extraordinary building in New Orleans that, in my opinion, I know some of you disagree with me, but in my opinion, would have saved taxpayers about $500 million and would have been up and functioning a year ago as a university hospital. But that's the old big charity building. I lost that fight. We're in a new building, $1.2 billion. We're going to make it work. We've got to. We don't have a choice. We just spent $1.1 billion of taxpayer money. But the argument was made at the time that we have to have a new hospital, because the old charity building, it's just, you can't go in it, you'll die, you'll get, diseases, and it's tumbling down, and it's no good for anything. Well, all of a sudden, of course, we find out that's not the case. The administration wants to sell it to the private sector so they can build apartments. We need to be real careful here, folks. There's not a lot of transparency in this process. The governor and the commissioner have unilaterally decided they wanted to see proposals. There are 4 proposals from the private sector. They were not shared with the taxpayers, the public, or the press. The press had to go file a public records doctrine request to get copies of them. That's a very valuable asset. As best I can tell from looking at the proposals, the biggest price offered the state is $30 million. The developers are also requesting a ton of tax breaks to develop the building. All I'm saying is, A, we've got to do something with Big Charity. It's a beautiful Art Deco building. We should do something. I wish we had a hospital in it, but we don't. We've got to do something. It's very valuable, and this is a decision that ought to be made involving the new legislature and the new governor. I don't want to see this administration do this, make a deal with somebody in the private sector going out the door. It's too important. I'm not suggesting it would be a bad deal. I'm just suggesting that Sunlight's a pretty good antiseptic, and I would respectfully, and I will be sending a letter to the governor asking that he please slow this train down and let the new governor and the new legislature be involved through a public meeting in deciding what's the best use for New Orleans and the Louisiana taxpayer of that new building. And I think that's very important. The legislature raised taxes $827 million. They did $400 million of that without a 2/3 vote. To me, Article 7, Section 2 of the Constitution is very clear. It takes a 2/3 vote on all tax matters to pass a tax. There's a reason for that. The voters put that in the Constitution because they don't want taxes to be raised just on a whim. They want there to be deep and broad support, and a dang good reason if you're going to raise taxes. That's why they put a 2/3 vote requirement in there. It's been the law in Louisiana for 100 years. It's not only in the 1974 Constitution, it was in the 1921 Constitution. The business communities file suit. I don't know who's going to win. Maybe the legislature will win this thing. But I think if the legislature does win and prevails in its opinion that it can raise taxes without a 2/3 vote, it'll be because the courts think the law is unclear. I don't think it's unclear, but if the courts rule that way, we need a constitutional amendment to make it very clear. If it's not clear now, though I think it is, that to raise taxes, to raise fees, takes a 2/3 vote. That's been the law for 100 years in Louisiana, and I don't think it's changed, and I don't think it should change.
What is the outlook for the current budget here?
We're limping along. Probably the next governor will face a deficit between $700 million and $1 billion. That's not good, but it's better than the $1.6 billion deficit we had. My immediate concern is to get through the year without any mid-year budget cuts. I don't know whether we can or not. We've had 6 mid-year budget cuts, which is a sign your budget isn't balanced, since 2010. They hurt. They generally fall on the backs of higher education or health care. I'd like to see us avoid it, but I can't promise taxpayers that we will be able to, because we're still doing what we've done for the last 7 years. We're still spending more money than we take in. And we still spend too much of it on things that politicians want as opposed to things that taxpayers need. And as long as we do that, then I don't care how high they raise taxes, we're going to run a deficit and live paycheck to paycheck. I'm hoping the new statewide elected officials and the legislature will address that issue. The real issue for Louisiana state government today is very simple. Forget about revenue and taxes and fees. It's how can we lower our costs while still being able to deliver a decent product. Some of my colleagues disagree with that. They think we're just one tax increase away from prosperity. I'm not buying that. I don't agree with them.
What about the future of Big Charity Hospital building in New Orleans?
Well, I don't know what the administration has planned. It looks like Commissioner Nichols and Governor Jindal are planning to do some kind of deal with a private developer before they leave office. And I think that's a mistake. They're lame duck. They're out of here in a few months. Governor is out of here now. That's a hugely important building. It's a very valuable taxpayer asset. I think whatever decisions we make about it ought to be made in public meetings where taxpayers and the public can see what we're doing. I think the legislature needs to be involved. I don't know who the next governor or the next treasurer, the next legislator is going to be, but they ought to be involved. I don't want to see the governor and the commissioner just pick a favorite from the private sector and unload a very valuable asset on their way out the door. I don't think that's right. I'm not accusing them of anything, but they do have a track record of unilaterally on their own in secret selling state assets. And I think that'd be a huge mistake and an insult to every taxpayer in this state and in New Orleans.
And your feeling regarding the security for the governor on his out-of-state travel?
Well, governors need protection. You know, there are a lot of nuts out there, and I think the governor should have state police protection. But he's not being governor right now. I mean, he's running for president of the United States, and he's got $10 million in his campaign accounts. I think that while he's out of state campaigning, he needs to pay for his own security, and let's take those state troopers that are normally providing that security and send them to New Orleans. I also think that doesn't leave the governor unprotected. When he's in state, he needs protection. His family needs protection, but not when he's on the campaign trail in Iowa. He can take those troopers and put them in New Orleans. When we added troopers to the police force in the French Quarter, we cut crime by 40%. I also think the lieutenant governor needs to give up his police protection, his state police protection. He has state troopers that follow him around all day when he goes, does his business, and when he's politicking. That's a waste of money. Okay, no other statewide official has state police protection. I think the lieutenant governor needs, and I think he's being hypocritical criticizing the governor. I think they both ought to give up their troopers, and let's send those troopers to New Orleans or to North Baton Rouge or wherever the crime spots are, and let's fight crime. Most of the time, having all those troopers around is just a vanity thing anyway.
Tell us a little bit about the situation with the U.S. savings bonds.
The federal government is holding $16 billion in savings bonds that have matured and aren't earning interest anymore. They know who the people are. They just won't contact them to pay them. They want to keep the money. It's vintage arrogance and greed of the federal government. I hate to say that, but it's true. I, along with some other treasurers, have filed suit against the U.S. Treasury to try to get some of that money turned over to us so we can give it to our people. I think as much as $200 million is owed the people in Louisiana. We've lost some of them, these fights in court. We're winning some too, though. The treasurer of Kansas just won a suit against the Treasury Department in Washington to get back $861,000. We have a lawsuit on behalf of 1,400 bondholders. Not all of them, but it's some that I hope we're going to win. But we're fighting the federal government. They're just wrong. They've got the names. It's $16 billion. These are savings bonds that have matured. They're not earning interest anymore. They know who the people are. They just won't call them up and give it back. And we, as state treasurers, can do that through our unclaimed property program.
Speaking of unclaimed property, you've got a program in Baton Rouge coming up.
We're going to be having a mall day from 10 to 3 this Saturday at the Mall of Louisiana. We do this periodically. By we, I mean I and about 20 of my colleagues go out with laptop computers, and we invite people to come out and let us check their names and return unclaimed property. Last time we did this, I don't remember what we did last time in Baton Rouge, but in New Orleans last time we did it, we returned $400,000 in about 5 hours. So if you're around, come out to the Mall of Louisiana. We'll see if we have money for you. If you can't make it, go to our website at LA Treasury, LATREASURY.com.